Good afternoon and welcome to our Employee Exit Best Practices, the legal and technical sides of employee exits during the COVID-19 pandemic. Today's presentation is being co-presented by RMWBH Law, Briggs & Veselka Co., and Pathway Forensics. For more information about each company will be provided to you in the slide packet, which will be emailed after today's webinar. My name is Hope Everett, and I am Senior Counsel at RMWBH Law, and I work in the litigation section. I'll be serving as your moderator today. A couple of housekeeping items before we begin. If you have a question during today's presentation, please submit your question in the Q&A box. We'll try to get to as many questions as possible after each speaker, at the end after all the speakers. Today's presentation will count as 1 hour of CPE credit. That is for CPAs. To ensure you receive your credit, a few poll questions will appear randomly during today's presentation. Please submit a response to each of those poll questions. Joining me today are Justin Markell from RMWBH Law, Kevin Stewart from Briggs & Veselka, Noel Kirkish from Pathway Forensics, Mike Tripkosh from Pathway Forensics, and Greg Godkin from RMWBH Law. I will further introduce our speakers before their section of today's webinar. We'll begin today with Justin Markell discussing layoff considerations for employees. Justin is an equity shareholder in the Houston office of RMWBH Law and the corporate section of Practice Head. He's board certified by the Texas Board of Legal Specialization in Labor and Employment Law. Justin advises and counsels employers regarding various employment law issues. Among other things, Justin assists employers in crafting employment policies and contracts, and also counsels employers regarding issues related to the hiring, pay, discipline, and termination of employees.
Thanks, Hope. My name is Justin Markell, and thanks for joining us today. I'm going to be going over basic legal considerations when laying off employees or deciding to do a layoff or reduction in force. So first we'll consider some pre-layoff considerations. We'll talk about some considerations to avoid discrimination and retaliation claims. And then we'll talk about some kind of miscellaneous issues. So first, before instituting a layoff, what should employers consider? Well, first is, do you even need to do a layoff in the first place? Would a hiring freeze or promotion or transfer freeze help reduce costs? Would a furlough help reduce costs without having to go through a layoff? Or would a temporarily reducing hours or pay do that as well? If you're considering reducing employees' pay commensurate with the hours that an employee is going to work, I just be careful about messing with that when it comes to exempt employees. For employees under a white-collar exemption, you need to be able to pay on a salary basis. And generally what that means is that the employee's pay can't be tied to the amount of work the employee produces or the number of hours that the employee works. So if you fluctuate it back and forth, the employee might lose their exemption. Besides those pre-layoff considerations, it's useful to consider certain things in order to avoid potential discrimination claims and retaliation claims. In avoiding discrimination claims, really documentation is key. You should have documentation as to what kind of criteria you're using in layoffs, how you're making those selection decisions, who's making those decisions, whether they're reviewed by anyone. And then even after going through that selection process, whether that selection process or the criteria you're using might create a disparate impact. And if so, what you would do about that, whether you maybe alter the selection criteria or take other measures to avoid a potential disparate impact claim. And for those that don't know on the call, disparate impact claims are basically claims by employees that although a termination decision might be based on legitimate reasons or business reasons, a disparate impact claim asserts that regardless of those neutral reasons, the decision or layoff process or selection criteria has adversely impacted a particular protected class, whether that's based on race, religion, sex, national origin, disability, age, and those kinds of things. So what kind of criteria can you use or should you use? Seniority is by far the best because it's really cut and dry, and it generally avoids these kinds of discrimination claims, especially because it's you tend to keep older employees, and so the more recent employees end up getting laid off first. But if you're not going on a seniority basis, there are other neutral criteria that have been approved by the courts, and they're listed here. When considering performance, I would just note a lot of people, when they do performance reviews every year, they just like to be very complimentary and non-confrontational. And so if you're going to use performance as a metric in doing a layoff, then I'd consider, are these evaluations really accurate in the first place? Or should you use like a special kind of rating system or special criteria, like can this employee do multiple kinds of jobs? Do they have skills that translate to jobs that would have to be filled, or roles that would have to be filled post-layoff, and that kind of thing. I'd also note that if you're looking at compensation levels as a metric or consideration for a layoff, I would just be very careful. Those kinds of considerations can backfire on an employer. They might result in an age discrimination claim because in certain companies, older employees might be on the higher end of the compensation scale. In addition to avoiding discrimination claims, it's important to avoid retaliation claims as well. So when going through layoff criteria and seeing who ends up on the selection list based on those criteria, it's important to note, has anybody on that list taken any protected activity recently? That could be opposing a discriminatory practice, complaining about harassment or discrimination. It could be requesting leave under the FMLA. It could be requesting an accommodation because of a disability or because of religion. It could be somebody who's also taken military leave. That's also considered protected. In addition to avoiding discrimination and retaliation claims, it's also important to look at some other things like, does the employee have an employment contract? That contract, if it exists, executive employment contracts might hinder your ability to do a layoff, or at least if that person is within the selection list for a layoff, it might result in a company obligation to pay severance. Something else noted on this slide, an independent review committee might help to avoid discrimination and retaliation claims. This kind of committee would take people from different departments, and they'd be really just act as like a backup to review decisions for legitimacy after the kind of lower level managers make preliminary layoff selections. And then finally, consider severance packages. Severance agreements are very useful in layoffs, particularly because if they're signed, they provide the company a release of claims. And so you get finality, and you know that once the agreement is signed and returned back and severance pay is given, that you don't have to worry about a potential claim in the future. Finally, I just note that for employers with over 100 employees, if you're going to engage in a reduction in force or a layoff, you have to look at whether the WARN Act would apply. Now, the WARN Act is a statute that requires 60 days notice of certain kinds of reductions in force. Those are legal terms being plant closing and mass layoffs. Those kinds of reductions in force, or those defined terms, are very technical, and it's a little bit more detailed than what I can go into today. But just generally speaking, it involves a loss of an employment loss of over 50 employees at a single site of employment. And there's aggregation rules as to whether multiple rounds of layoffs can be considered one for the purpose of the WARN statute. You generally have a 90-day window that you need to look at to be able to see whether that advance notice is required. So hopefully with that, you'll have a better idea as to what kind of legal considerations to consider to avoid discrimination claims, retaliation claims, and other things to consider when thinking about layoffs. I'll pass it over to Hope.
Thanks, Justin. Next is Kevin Stewart. Kevin is an advisory principal and client account service practice lead at Briggs & Veselka. Kevin has been with Briggs & Veselka since 2017. Kevin brings 20 plus years of experience turning around and building accounting and finance teams to remediate failures, stabilize the now, and create environments to support growth in a wide range of industries. Kevin is a member of Briggs & Veselka's SBA PPP task force. Today, Kevin will be speaking on the issues of PPP loans and forgiveness with employee exits.
Thank you, Hope. Being at Briggs & Veselka, and just to provide a little bit of background about our firm, is we are the largest independent firm headquartered in Houston, Texas. We have approximately 350 professionals between Houston, Austin, Woodlands, and a couple of smaller locations across Texas. A few months ago, or I guess 5 months ago, 6 months ago or so, the SBA came out with the CARES Act, and we've been pretty heavily involved from the very beginning, just trying to get an understanding. How does it impact us? How does it impact clients? And also just the local community of business. So performed a lot of webcasts, done a lot of deep dives, and I've sometimes questioned, why are we actually doing this, right? How is it benefiting us? But I think really the truth is we're doing this to provide goodwill back to the community, and just to help our friends in the community within the business perspective. So the next several slides, I think I've got about 9 slides here, but I won't be speaking too much directly to them because there's a fair amount of information on here. So if we think back to PPP, the intent of that was really to keep people employed. And the way to do that was through this loan, the Payroll Protection Plan loan, by which to get the funds from the US government, this grant, this help, this whatever else. And it went through the banks, right, to facilitate an ease of transferring those funds to it. And so what came with that was this loan process. So the intent was to get funds to employees to keep employment, because there's just a lot of concern overall that there are going to be these layoffs. There's going to be a reduction in business. And there has been some of that. But I don't think any of us really knew what to expect back in March 18th, 19th, whenever that time frame was, when all this kind of really started impacting Houston for the most part. And so thinking about this, by getting those funds to businesses, and not for those businesses just to pocket those funds for themselves, there's kind of these thresholds to help protect employees and protect that this money is actually being used for what it's supposed to do. And so kind of with those strings attached to the loan, there is these impacts of saying, if you don't spend, if you don't maintain employment at certain levels, and if you don't maintain pay at certain levels, then we're going to reduce that. For when I say we, I mean the SBA and the government is going to reduce the amount of that loan that could be potentially be forgiven. And so on this slide and the next slide both, it kind of talks through kind of what that reduction might potentially look like. And I believe there's 5 steps here. But effectively what it's doing is And again, when you refer back to this, just know that this is all just math, right? And when sometimes math is complex, and if you're like me, you barely got through business calculus for dummies, but it's just math, right? By reading the instructions, looking at the math, you're going through these steps. And so this initial measurement period, I believe March 31st is kind of that date. You're trying to get an understanding of what that covered period is. What is your benchmark by which you're evaluating yourself against for forgiveness? And kind of with that as well, the intent is this is intended for employees that are making $100,000 or less when you annualize that. So if that's an 8-week period, it would be 850 seconds of whatever the annual salary is, and you'd annualize that. So anything above 100,000 would be excluded from forgiveness, excluded from getting loan money for as well. But as you're going through these steps, you know, it's computing the average annual salary or hourly wage of during the covered period or the alternative cover period. So that's your time frame by which you're evaluating. And so what is the pay during that time period? It's computing the average annual salary for that benchmark period, which was January 1st through March 31st, 2020. So you're comparing that step 2 to the step 1. And you get into step 3 and you're kind of dividing what is the impact? What really is the impact where you're going? And where we're on this slide now is you get to step 4 and step 5. All this is really attempting to do, without going into extensive detail here, is in comparison, was the money that you got for this payroll, was that actually used for payroll? Was it delivered to, and did you maintain the head count? Did you maintain FTEs, which we'll talk about in just a minute? Or were the funds used for something else, something not necessarily intended? So as we move in kind of that, there's a safe harbor concept on this next slide. And the safe harbor concept is really, if you're a restaurant business or in that hospitality business, they were significantly impacted early on. And so by paying salaries to people who aren't working, is that the best use of funds? And that's for every business to decide. And so in calculating the safe harbor, it's looking at, again, that annual salary. It's comparing that annual salary to what was the actual pay during that covered time period, and is one greater than the other? Is this calculation the same or greater than the one before? And if it's the same or higher, right, if what you actually paid out is the same or higher, then you're good, right? You just kind of move on. However, if that funds is reduced, if they were less than, you know, for not good reasons, were they less than, then potentially there is no safe harbor. So moving even further than this, within that safe harbor as well is, got off track there, I'm sorry. Getting that safe harbor as well, you get into really full-time equivalents. And so how do you measure the number of employees? Because different employees make different amounts. And so how do you maintain that? And so it really is, when you're going through this process, you have to evaluate on an employee by employee basis, right? So this employee was at the beginning of the period, this employee was at the end of the period. Did the pay change? Did the hours change? And so the way that you can do that is through this full-time equivalent. There was a lot of debate initially early on saying, what is an FTE? How is it defined? And it wasn't defined. And so we're trying to find this specific guidance from the NSBA, similarities. They ended up coming up with these basically 2 calculations. And one is assigning, is you're measuring it, you're doing a calculation, and you're dividing those hours by 40. I mean, it can't exceed 1, so you can't have an employee that's 1.2 full-time FTEs. And kind of the same, it doesn't really go below, you know, a half necessarily. So you can either round the decimal to a 10th place, or you can assign a 1/5 to every employee, to each employee. And you can see, at least on that simple example there, that there may be some variances there. And so when you're going through the process, if you did get a PPP loan and you're calculating what is your FTE, it is beneficial to do some analysis in addition to saying, well, this is just the number that we have. And if we move on to the next piece, we kind of talk about the FTE just a little bit differently. And it's around safe harbors, and it's the Fte Reduction of safe harbor. So the borrower may be exempt from the reduction of loan forgiveness if the borrower was unable to. I need to answer my poll question here real quick. So yes, maybe. So the borrower is exempt if you're unable to operate at the same level based on specific criteria. So based on the impact of decisions made outside of your control, based on decisions made by the Secretary of Health and Human Services, maybe the CDC or occupational safety. If there's reasons why that you're prevented from actually, you know, delivering the service, being in operation, those types of things, those are reasons, justifiable reasons to come back and say, you know, we couldn't operate. We had no ability to operate because you didn't allow us to because of your laws and your legislation. And so when that happens, then you get the exemption from that safe harbor. Like you don't have to reduce the funds necessarily to be paid back. When we move into safe harbor 2, excuse me as my voice cracks, the borrower could be exempt based on if the borrower was able to return to FTE levels as of December 31st or at the date of the application. And so you can, within this time period, you can, you know, wait all the way until December 31st. We have had several clients that we've engaged with and visited with that they are holding off from filing their application because they did have to do a furloughing a little bit, a laying off for the meantime to potentially bring them back as business picks back up. Some of that is indirectly seasonal, some of it is not. Some of it is just based on the way that the business works, and some of it has truly been impacted by COVID. So they're holding off to file for this forgiveness until they're actually able to bring these people back when business recovers, when it hopefully recovers, right? So if you get to that time period, you're able to hire back as of December 31st, or when you file the application for forgiveness. If you've hired back again, you've got a little bit of you've got a safe harbor there as well. And so there are some reference periods for evaluation to see if they're being satisfied. All this, again, if you go back to the original intent of PPP, it was to maintain employment levels, it was to maintain salary levels, it was to maintain pay. So the intent here is really, let's make sure our people are employed, right? So they're giving you some leeway here. They're giving some grace because this is extended on, I think, far beyond what everyone initially expected. So when the FTE reduction doesn't apply, the safe harbor doesn't apply, when there is no safe harbor for FTE reduction applies, the bars basically calculate the reduction quotient on Schedule A. And I think we'll have a Schedule A here in just a minute, but and it's entering on line 7, but you're basically doing a calculation. So if a specific employee's salary has reduced by more than 25%, then there's a reduction. If there has been potentially employees reduced by more than 25% as well, there's also reductions there as well. And considering that, right, I think there's 2 components to the PPP. There's the actual payroll piece of it, and then there's the non-payroll piece for like mortgage interest and rent expense and all these types of things. And that's kind of where we get to that 75% area. So by going through these calculations, by doing the math that we all hate, right, we come back to, is there some sort of reduction or quotient that needs to happen? And you're taking that quotient and you're multiplying it, or I guess on the next slide, you see where there's the schedule, you're inserting it in to get to the average FTE, you're kind of comparing back and forth. And then moving to the next slide as well, just kind of jumping forward. If an FTE reduction has taken place, it's important to keep in mind that there are also exceptions. Now, if you have $1 million loan and you did have reductions, there may not be much a way around it, right? You made your choices, you got some free money per se, but a piece of that does need to be paid back, or it needs to be paid back over the period over the loan of 2 years or 4 years, whatever that time frame is. But there are exceptions. There may be reasons that the employees left, right? So what we saw in some instances was people were taking early retirements. You said, I don't need to be out. I don't have to work from here. I'm going to work from home and I'm going to be good, right? And they chose to do that. In that instance, that person that you didn't choose them to push them out, you didn't have them leave. You may not have replaced them, but they left their own volition. Well, that would be excluded. So when you're going through your payroll, when you're going through your calculation, then you would effectively add them back in because they would count as an FTE. If you fired somebody for cause, right? There's no reason that you have to maintain them. If there's a legitimate cause, it's having that documentation. We talked about voluntary leaving. It may be that people they went on, you furloughed them for a time, they're on unemployment a little bit, but unemployment's better than what they're going to make if they come back, which is silly, but that's just the way it is, right? In those instances, if you have documentation to say, you can come back now, we want you to come back, and they say, no, I'm good, and you have that documentation, you have that email, you have some sort of other documentation to say that you made a good faith effort to have them return and they chose not to, well, again, that doesn't penalize you. You can add those back in as well. So if any of these exceptions apply, borrowers will want to keep very detailed documentation. You'll want to keep the emails. You'll want to keep maybe the phone records, the phone log of who you talked to and when you talked to them and those types of things, and just capturing that information. So in the event that the SBA, God forbid, knock on wood, comes back in and says, we need more information here. We need, why were these people let go? that you can easily just provide that back to them. So when making these decisions about, should I furlough, should I lay off, should I let some people go, there is a timing aspect here. And there is kind of this perception as well as when it happens. So you just want to make sure that you're going through the right steps, you get the right documentation in place, and that you're doing what really is best for the business and potentially for the employees as well. But if you have questions, if you have concerns, if you have thoughts, please feel free to put a question out here on the chat, or follow up with me offline afterwards. But I appreciate your time, and we move on to the next one.
All right, thanks. Next up is Noel Kirkish. Noel is the managing principal at Pathway Forensics. He has 20+ years of experience conducting digital forensic acquisitions and analysis on a variety of cases. He is ENCE licensed PI in Texas. Today, Noel will be speaking on digital forensics during employee exits.
All right, well, thank you, Hope. Good afternoon, everybody. Again, like Hope said, my name is Noel Kirsch. I'm with Pathway Forensics. We've been around since 2008. We're a computer forensics, e-discovery, and cybersecurity firm. Our headquarters are in the Woodlands. We also have offices in Houston as well as Austin. So we were acquired by Briggs and Veselka in 2018. So today I'm going to be talking to you to try to answer 3 questions primarily. Number 1, what is digital forensics and what role does it play? Knowing that this audience may not be digital forensics experts or attorneys, my goal here really is to kind of do some education on what is digital forensics if this isn't an area that you are familiar with. Another area we're going to talk about is how can digital forensics help departments such as HR with employee exits, and then why use a digital forensics expert when I have an IT forensics or IT department. So that's a very common question that we get, and that's one I want to address today in this webinar. So digital forensics is a discipline that's dedicated to the collection of digital evidence for judicial purposes. So for the non-attorneys in the audience, there are rules of evidence that are required by courts to be followed in order for evidence to be admitted into court. So we have our second poll question here. So do you believe your organization takes steps to ensure your IP is safe even when an employee leaves the company? So take a moment to answer that poll question. Hopefully your answer is yes. If it's not, then contact me. I'll help you with that. So like I was saying, though, there are rules of evidence that must be followed before evidence is allowed into court. So, for example, if I were to file a lawsuit and there was an email that I wanted to have admitted into court to prove my case, I can't just print that piece of or that email off and take it to the judge, and the judge allows it into evidence and then considers that for their decision. That evidence has to be, verified to be what it purports to be. And so I can't, in other words, I can't just create evidence and give it to the court and have them rely on it for their decision. It has to go through a process whereby it is verified to be exactly what it purports to be. And that's where digital forensics comes into the fold. So we help you meet those rules of evidence so that the evidence can be admitted into court. I always tell my wife that as long as there are people doing stupid things in their computer, I'm going to be very busy and we'll have food on the table. And so there's an endless supply of that, thankfully. So I'm going to be fine for a long time. So how can digital forensics help HR? So there's 4 primary areas I'm going to talk about today, and I'll go into detail into each of these, but the main areas are computer use violations, harassment, discrimination issues, internal data breach matters, and then really just to help preserve evidence. So in the area of computer use violations, we can do investigations of allegations of computer use violations. So a company has specific guidelines or computer use guidelines that employees are supposed to follow, and they don't follow them by, for example, viewing explicit material at work or spending too much time on the internet. So I've had a case before that a client said, hey, I think that this person is spending too much time on the internet, not actually doing work. And so they sent me this employee's computer, did an investigation of her web activity, and found in a 40-hour week, she spent all of 2.5 hours not surfing the internet. So that's hard to do. I don't think I could find 30-something plus hours of web material to keep me occupied at work, but somehow she did it. So I was able to provide that client with a report that, you know, an independent person, I'm not a party to the employment decision that's being made here by the company, that can say, hey, you know, there is some weight to the allegations that they're making against this employee, and therefore that allegation holds a lot more water when another person comes, you know, away independent of the company and says, hey, there is something here to their allegations against this employee. So another area is in the area of harassment and discrimination issues. So we can support or refute allegations of harassment and discrimination. All sorts of things can be found in emails, texts, and chat and instant messaging. And what I've discovered in a case example I'm about to give you is that this subject is not aware of what the computer is actually recording of her chat activity. So this is a real case. I promise this actually did happen. Several years ago, I got a call from, this is the next slide, I got a call from a client that I've worked with for many years. And he said, hey, we just received a letter from for an attorney that's representing a former employee. And she's alleging that, you know, she's suing us for sexual harassment. She's claiming that her manager used a very specific vulgar phrase to describe her to coworkers. And she was very, very offended by this. And so he said, I don't even know what to tell you to do, but just look at the computer and then tell me what you find. And so I got her computer, her work computer, examined it. And what I did is just did a search for that vulgar phrase that she claimed she said was being used against her. I was trying to find where, you know, where basically the manager had said that electronically. But what I actually found was that she was texting or chatting using Yahoo Messenger to chat with a coworker of hers who wasn't her husband, who was her boyfriend, and was using this vulgar phrase to describe herself in a very lighthearted, joking manner. So we printed all that information out. He faxed it over to her attorney, and that's where that matter died. So all sorts of things are being recorded by the computer, and just a simple investigation like that, it wasn't even $1,500. Was able to get them out of a lawsuit that was a lot more expensive than $1,500. So another area that we can help with is in the area of internal data breaches. So this is when an employee steals data from a company. This is typically when an employee puts in their resignation, and then they copy data to a thumb drive or US, you know, or cloud storage or email, webmail, the most common ways that data is stolen. We work with them to identify what was stolen and how it was stolen, and kind of recreate the steps of that person on the computer, and then assist them in getting their information back. So one example of this happening was this client called me and said, I'm going to send you over a cell phone that belongs to a former employee of mine. And it has text messages on it that, well, what they said was, I'm going to send you over the cell phone of a former employee. And go to the next slide. If you go, so they said, we're going to send you over the person's cell phone. I want you to take a look at that. And what we think is happening is that they're trying to take our employees and they're trying to take our business. And so we examine the cell phone, and this is what you're looking at is the software that we use to examine the computer, or examine the phone rather. This person actually did have 14,000 text messages, and you may not be able to see it, but there's almost 300 voicemails on this phone. But in the next slide, we'll actually show you what we pulled up. And so you can see here that what this is, the text messages that were sent, and those three that I've highlighted there were actually deleted text messages. You can see the first one says, I'm sending a customer, who should they contact? So this is proof that he was indeed sending a customer over to his new employer. This was before his last day. And then he said in conversation, some have non-competes, and then I have some employees that want to go with me. And again, these were messages that he sent on his company cell phone and then deleted them. And then we were able to get those messages back. And again, it proved that the allegations against this person were actually true. So if we can skip the next slide and move on to, I have an extra case example in there for you to review after this. Just in the interest of time, we're going to move on to the next area, which is talking about preservation of evidence. So this is my own poll question, but which of these actions will result in unrecoverable data? So this is just for you to the informal poll. There's no poll that's going to come up, but is it formatting a hard drive twice makes it unrecoverable? Deleting a file, then deleting it out of the recycle bin, which is also known as double deleting, hard drive crash or malfunction, or downloading and using free data wiping software. So in your head, I guess, answer which one of these would be, would render data unrecoverable. And if you guess the download and use free data wiping software, pat yourself on the back because you were correct. That actually will result in the data being unrecoverable on the drive. So everything else in that list, we have been able to recover deleted information from a device. So again, I've got two more case examples that are going to be in the slides. I'm going to skip over these and move on to the next, not this slide, but the next one. We're going to move on to talking about the IT department versus forensic examiners. So one of the most common things we get when we get a new case from a client is this situation is, hey, I'm sending over a piece of evidence and my IT department already copied some data off of there, but we want to know what what this person did. And I'm like, well, wait a second, back up, because if your IT department got on the computer and attached the USB drive and started copying data off of there, that really tampers with the evidence. It's sort of like sending a CSI team into a crime scene where the police have already, manipulated the phone or manipulated the weapon that was used to commit a crime, or they've moved the body, or they've cleaned up some evidence from the scene already, and then asking us to come in after the fact and try to recreate what happened. It's a bit of an impossible task to do. So IT departments are really good at what they do, but they're not digital forensic examiners. And I tell people that an IT person is not necessarily a computer forensics expert. That is like assuming an X-ray technician can perform brain surgery. Yes, they're in the same field, but they have very different training and experience. So just make sure that you're using a digital forensics expert to do digital forensics jobs and not using an IT person to do those jobs. So I've got a couple do's and don'ts slides here to round up my time here, but as far as IT involvement goes, make sure that you're preserving evidence before wrongdoing is suspected or found. Just make a copy of the hard drive before you suspect anything has been done. Turn off the computer and store it, and then establish a relationship with the computer forensics company before an incident occurs. In other words, don't wait for a fire to start before you start trying to find the fire department's phone number. And then don't allow allow the IT department to browse the computer, and don't attach a USB device. That's a big no-no. Last one for me is on mobile phones. Make sure that you're getting the passcodes for the phones before the employee leaves the company. That's important for us to be able to unlock the information that's on that device. Without it, we can't do our job. And then make sure that you're instructing your departing employees not to reset the device. That does delete everything off of the device. And then don't reassign the device to a new employee before they leave. And then don't delete any data from the phone. So that is my time today. Hope, I will kick it back over to you.
Thank you. Next, we have Mike Tripgosh. Mike is the Director of Cybersecurity at Pathway Forensics. He is a former CISO and cybersecurity consultant with over 30 years of IT experience. He spent the last 15 focused exclusively on cybersecurity, risk, and compliance. Mike is speaking today on the cybersecurity risks during employee exits. All right, Mike.
Thank you, Hope. So when we're speaking about exiting employees, I generally categorize them three ways. We have your non-malicious employees, and those are the folks that they leave on good terms. They're rehire eligible. They're generally great people and we're sad to see them go. Then we have the malcontents. The malcontents are unhappy, but they're still here. They have wanted to leave and they'll leave at the first chance that they can. Now, the one thing about them is I don't really consider them malicious. I consider them opportunistic. When they do get a chance to leave, they're going to take whatever they can with them that's available. And then third is we have the disgruntled folks. And the disgruntled employee is, they're not only leaving, but they're going completely scorched earth when they walk out the door. And what I mean by that is, depending on their access, they're going to leave back doors. They're going to destroy data. They're going to erase things. They're going to, depending on the access again, they may even set up dummy accounts so that when their account is disabled, they still have access. That generally happens in larger organizations, and it's a good reason to do a user account reviews. So what is the risk when an employee leaves? So any type of technology, especially now that we're in the digital age, technology can be stored. Massive amounts of it can be put on something as small as a thumb drive. You're looking at cyber technology, information network diagrams, policies and procedures, or any type of IP or sensitive information leaves with the employee. Disgruntled employees can, again, edit, delete, they'll erase information. They know how to use the free software Noel was talking about to make sure it's not available once they're gone. And they'll also send irresponsible emails to clients just to be naughty, I guess. Bad social media posts. There's all kinds of stuff that can go on. They have any type of important plans like your diagrams or data, they'll share it with competitors. And then the other thing they'll do is they'll oftentimes send employee or customer information. They'll give it to competitors or just outside individuals with malicious intent. Looks like we have a third poll question here. Would you like your organization to train employees on how to identify phishing emails, i.e. emails that might have bad links or attachments? I'm going to go out on a limb here and I'm going to guess yes, but I can't answer it. But so one of the ways that we begin to mitigate this risk is to develop an employee exit strategy. Now, when do we do that? The employee exit strategy should begin the first day an employee is hired and it continues until their exit interview. What do we have as part of this strategy? We should maintain a record of all the assets that they have, whether it's phones, laptops, anything that they may have access to and have in their possession. We need to keep a very good inventory of all the access that they have, both internal and external accounts and systems. And what I mean by external accounts could be like a Salesforce. Internal accounts could be any type of legacy accounts within the organization. And if possible, in a perfect world, what we would do is we would have all of our employees bring all of the equipment they have to their exit interview, and we would disable access while they're in their exit interview. Unfortunately, that doesn't happen very often. And even now with COVID and the entire workforce is almost remote, it provides us with a lot of challenges to do that. So that's really important to have the strategy in place and think about that strategy before you bring those folks in for their exit interviews. One thing that can help with this is what we call identity and access management, or you may have heard the term IAM. What this is it's an overarching program type solution that is a hierarchical view of all the access that an employee has. And it generally provides you with a one-stop disconnect to where you can shut off all of their access at one spot and then go back slowly and remove access and ensure that there's no orphan accounts. And orphan means you've got access to an account, but no higher access, like you might remove them from Active Directory, but they may have access to smaller systems. That's especially prevalent in single sign-on. And then finally, as part of the strategy, we want to ensure that we're going to change all the passwords to applications and systems that the employee works directly with. But then we're also, keep in mind, you need to, if you have shared accounts, these are the ones that are come back to get you in the long run. You want to make sure that those passwords are rotated on a regular basis, or especially when somebody leaves that has a higher level of access. Delete or disable any accounts that belong to that individual, and remove any permissions that they might have to any types of networks, especially if you have access to a client's network for one reason or another. Make sure that that's removed and send them notification that that employee has left the organization. And then consider whether the employee had access to any co-workers' accounts. Again, shared accounts, or if they just knew of another co-worker's accounts, again, it might be wise to rotate the passwords. And then by examining what an employee does on a day-to-day basis and keep a record of that, it's much easier to make sure that you don't miss anything. And that's pretty much all I have. So Hope, back to you.
All right, thank you, Mike. Our final speaker today is Greg Godkin. Greg is an equity shareholder in the Austin office of RMWBH Law and is the litigation section practice head. For over 20 years, Greg has represented some of the world's largest corporations, as well as individuals in the areas of complex business and corporate litigation, directors and officers liability, and fiduciary duty. Greg is speaking today on protecting intellectual property in the remote work age.
Thank you, everyone. I appreciate you guys tuning in and hope you're learning some things. I don't think anyone ever anticipated we would be experiencing the situation that we're in today. The pandemic has obviously created a number of challenges for employers as well as their employees. The main challenge that we've seen, and I know it's uniform throughout, is the number of people working remotely. The likes of which we've never seen before, and probably may become the new norm, at least to a greater extent than ever anticipated. Because of that, there are a lot of issues that arise as it relates to employees. Most employers, from small to large, have employee handbooks, which essentially establish the policies and procedures of the company. Seldom, if ever, did these employee handbooks ever contemplate the number of employees that would be participating remotely. The challenges that arise, everything that we've heard a little bit today from some other speakers, security, confidential information, the use of home equipment, and the vulnerability of security risks. All of these are challenges that no one anticipated. And so we're seeing a lot of clients come to us and say, what do we need to do to address these ongoing concerns? Because in the very least, it's going to be several months before we go back to normal. But most likely, we're going to start seeing remote learning, not remote learning, remote workplace as a norm. One of the things that comes about is just confidentiality to begin with. When people are at work, they tend to, in a work environment, keep things more private and confidential than they do in their own home. Today, you have folks using their home computers that may also be used by their roommate. It may be used by someone else in the household. Having a policy in place that essentially separates out the use of that computer by other people to make sure that that information that is confidential to the employer is protected is absolutely key. There are several steps that can be undertaken that are quite simple that will prevent some sort of confidentiality breach that could result in anything from a very angry client or customer downright to another outright lawsuit. And these are things that can be addressed in an employee handbook and those matters can be before something ever comes awry. Another issue that I know we're going to see a lot of, and Justin somewhat touched upon this, is how do you make sure that employees are essentially not violating the overtime requirements, over 40 hours. I know of a lot of employers that have done surveys, including our own, that have talked to the employees and saying, look, when are you working during the day? And we're seeing a lot of times all over the place in terms of, well, if you have children at home, you have a situation where they may be working really early from say 7 in the morning till like 10 o'clock. And then they've got issues to deal with the household. And then they're coming back on in the afternoon, and you may see them go off again and then come back on in the evening. One thing that I'm absolutely sure we're going to see is a number of lawsuits that come about after COVID, where the employee is going to allege that they were working overtime and they were not getting paid for it. It is absolutely critical that the employee handbook address these issues to discuss the necessity of getting getting approval before overtime is approved, before it's undertaken. Sorry, the poll question just came up and it kind of threw me off. What type of workforce does your organization plan to have in a new normal post-COVID? I can't vote, but we're certainly going to have a hybrid. I don't even know what a different type of structure not listed here would be. I'd be curious to hear that. Any rate, there's several things that can come into play to make sure that that doesn't happen, or at least alleviate some issues that may arise. Having approval beforehand, that sort of thing. And again, this is high level. I'm trying to cover issues that just are going to require a lot more work on a specific basis, depending on what the employer-employee relationship is. But these things just to keep in mind. Standards of conduct policy. This is another one that I think we're going to start seeing a lot of litigation come out of. People are operating at home for a business, but they may not be operating like they're at a business. I actually had a call from a client the other day where their employee, along with another, went to a restaurant and decided to have a few margaritas, and then they were involved in an accident on the way back. And the question arose, well, am I going to get sued over this? Or then the course and scope of employment? Well, technically no, but I told the employer, well, ultimately at the end of the day, you may beat the rap and not the ride. These are things that you want to cover in your employee handbook. When you may be working remotely, but when you're on the clock, you are operating like you're in a business atmosphere, and it needs to be treated as such. Go to the next slide, please. One of the things that can be done to help alleviate some of the issues that may arise when employees are working remotely, and also upon exit, which kind of touched upon some of the earlier speakers, is confidentiality and non-disclosure agreements. I could speak for hours on NDAs and proprietary right agreements, but essentially what you're looking for is an agreement on behalf of the employee that upon termination or a voluntary going elsewhere, that that the information from behalf of the employer is protected. Again, these become very detailed oriented. Their enforceability is a subject of countless lawsuits and course opinions, but there are things that can be done to protect client information and proprietary information that are enforceable in a court of law. It's very, very, very important, in particular as we're working more remotely, that these are addressed in the hiring stages and in the employee agreements as well. Okay, go on to the next slide, please. This kind of touches upon some of the earlier comments as well by the presenters. What do you do upon exit procedures? Making sure that the employer information is protected, that that client information is protected, proprietary information protected, et cetera. One of the things that we've seen before is when you're, and again, it depends on the type of employee that we're talking about, which was just addressed by Mike. Is this a situation where it's someone that just we're sad to see go, or someone that we can't wait to see them go, but in the meantime, I hope they don't burn us down in the process? But depending on the type of employee and the situation, there are several things that can be done. One of them is making sure that there is in compliance with any non-disclosure or proprietary information agreements. We, in certain circumstances, depending on what has happened and the risks that may occur if we don't, is recommend that the new employer be reminded of an NDA. Now, with that, there's a caveat. I was involved in a lawsuit 2 years ago where our client had taken upon themselves to do exactly that. That employee was terminated on about the 5th day of employment. And the allegation was, well, you didn't tell us you had an NDA, and so you lied, and we found out later, so we don't want you. That employee then sued my client, his former employer, for tortious interference. The moral of this story is there's some times that employers try to do the right thing, but the manner and method which they're doing it is wrong. I highly encourage you to speak to counsel before anyone goes down that road. Again, a lot of times what I get are clients that come in and they feel that they're very justified in with their behavior, and they are. But again, it's a process in which you do it, and doing it wrong can lead to bigger problems than you had in the first place. Going to the next slide. I think this is actually a repeat of what we had talked about earlier. One of the things I do want to talk about real quickly, and I'm running out of time, is we're often asked, okay, we have an employee that has taken proprietary information. They're stealing customer lists. They're seeking other fellow employees to go with them, even though they have an NDA, which one of the presenters showed earlier. What is a process? What happens? And typically, what is done is once a lawyer is involved, is an immediate lawsuit is filed, and what's known as a temporary restraining order is filed with the lawsuit that asks the court to immediately prohibit that employee from creating any additional harm. That next step is what's called a temporary injunction hearing. That is where, frankly, these cases are won and lost, and that's where employers have the most power, because the temporary injunction hearing is essentially a mini trial. And what in the right case with the right facts, a judge will actually tell the employee, pending this lawsuit, which could go on for years, you are prohibited from doing certain things, which essentially hamstrings that employee from hurting his former employer, which could include, but not limited to, seeking employment with a competitor in the state of Texas or the counties in which he or she was working, from contacting any prior customers that this employee worked with while he was employed with the prior employer, contacting fellow employees to come over, that sort of thing. And really it gives the employer the opportunity to essentially do some horse trading and get what the employer wants in the best manner possible during those negotiations, because again, the employee is really at that point hamstrung from doing what he or she thought that they were going to be able to do. I believe my time is up, if I'm correct. I just got a notice. So again, this is high level. There's a lot of detail in all these presentations, of course, but if you have any questions that we can help you with, our contact information is in the materials, and we'd be happy to help and talk to you any way we can. So thank you.
Thanks everyone, and thank you the speakers for everybody for being here and I'm giving this information. There are a couple of questions that were submitted. Those are going to be sent to the speakers. We do have time for one, and it's to Pathway. So the question is, can you look and an employee cell phone that's not a company phone?
Actually, this is a bit of a legal question, but in my experience, what I've seen around this is that you have to have the employees their authorization to do so, or most commonly it's ordered by a court. So they go before the judge, the employer goes before the judge and says, Your Honor, we need to examine this phone and provide good reasons for doing so. And then the court will then order them to turn over their personal phones for examination. So those are the typical scenarios that I've seen in examining a personal cell phone.
Anybody have anything to add? Okay, well, the presentation will be sent to y'all via email, and the questions that weren't answered today will be also sent to those respective speakers, and you should be contacted. And thanks again for joining.